Hello, everybody. This is Keith Caldwell with Failure to Plan, and I've also got with me our special guest, Ryan Platt. Hello, Ryan.
Hey, how are you doing, Keith?
Good, good. Hey, my voice is back this week. Oh my goodness! Last couple times we talked, I had a strep throat and couldn't talk at all. So I'm going to be able to ask questions this time and participate more actively. So why don't you go ahead and introduce yourself, Ryan? Tell us a little bit about your company, and then we'll go ahead and get started.
You got it, Keith. It's my name again is Ryan Platt. Have a firm called A Special Needs Plan, and what we do is help families create a plan for not only their child that has a special need, but kind of how that plan fits into the entire family's plan going forward, so that everyone in the family can have as much independence as possible at every stage of their life. And so we can kind of, as parents, rest easy knowing that things are in place for our child's future, and that it's going to happen no matter if parents are here to see it through to fruition or if something happens and they're not here.
Right, right. Hey, I appreciate that, Ryan. And I should just give everybody a heads up that my 10-year-old is here with me, so he might be popping in and out of the screen. But if other parents with kids with special needs can't be understanding, then I guess then we have issues.
That's right.
So we're going to go ahead and get started. Oh, let me introduce myself. My name is Keith Caldwell with Failure to Plan, and I am not a financial planner. I'm not an attorney. I'm not an insurance person. I'm just a dad who is trying to help figure this out for myself, and called Ryan and started talking to him about what his services was, and we decided to come up with this series of educational videos to sort of educate me and to educate other parents. So that's what this is all about. And today's topic is guardianship. Big issue for a lot of us because as our kids get older, we need to make sure that we have the proper legal things in place to continue our ability to manage their affairs if it's appropriate. So with that, I'll go ahead and let you go ahead and get started, Ryan.
Yeah, I mean, I think, Keith, you kind of hit it on the head right there to start us off with, which is, guardianship in its own is sometimes we don't even know what the rules are.
Right.
So, for example, a lot of parents won't even know that at age 18, our children become their own adult. Right, and so at 18, the court system and the states consider them with the ability to make any decision that they need to that's appropriate for their life, whether they have the ability to understand the consequences of those decisions or not. And so as parents, the first thing we want to do is make sure that parents are educated that 18 years old is a very important transition point. That's one of the transition points for your child that's very important to understand, not only on the guardianship side of making sure that if they do need help making, I always think of healthcare decisions or financial decisions. If they need help in making those choices, then guardianship might be something that we need to do at age 18. And then the other pieces are certainly, there are certain government benefits that can come into play at age 18 as well. If again we're structured properly financially and legally, which I know is not the topic of today's item, which is topics of others that we've done. So to kind of stay on the guardianship, it's very important at age 18 that we keep that in mind.
Mm-hmm. Do you know, Ryan? I'm sure you do know, but I was thinking as a parent, how long of a process does it take? I mean, is it something that we should get started when they're 10, 16, 17? How long does it take to do it if something we need to do?
Yeah, I mean, that's actually a really good question, Keith. And what I always tell folks is that, start at like 6 months before. A lot of times it won't take that much time. But again, it just gives you enough leeway, I guess I would say, or enough flexibility, so that you can get all the proper paperwork. You can go to you have to go to the clerk of court's office in your county and where you live to get the proper paperwork from them, and then be able to, you can fill it out appropriately, and get it back to them within a time frame, so that, you know, when your child turns age 18, everything's in order, and those proceedings can move forward for you.
How does that look for a parent? I mean, I know my son's only 10. As you see him keep walking in and out of the screen, I'm sure he'll have something to add in a little bit, but
that'll be great.
But
it's about him we're talking about anyway, right? So he should have.
It is about him. It is exactly about him. And for those watching, I'm sure that they have their own ones that they're interested in. But how does that look? I mean, I know a lot of parents have been blindsided, you know, when the kid turns 18 and they're still in the school system, all of a sudden principals and teachers and everyone is saying, hey, I can't talk to you anymore if you don't have this all set up. How does that look?
Yeah, I've actually had that happen to a few parents, and they've come to me and say, wow, I really need to get this done, because I wasn't able to go to my child's IEP meeting.
Right.
You know, they didn't even notify me that it was happening, because they don't have to, right? They don't have to notify anybody that's happening once they turn age 18. So that's one piece that where it can really be quite present and very visible for a family in that situation. It can also be visible in medical situations, right? I mean, not probably, you know, in reality, when we talk about how things actually work in the real world, you know, if you've been to the same physician and they're still with their pediatrician and those kind of things, you know, on those kind of visits, they're probably going to still, you know, have you as a member of that meeting, as long as your child kind of nods their head and says it's okay, right? But it's those situations where, you know, if all of a sudden your child needs a surgery or something like that, and they don't want to go do that, they don't want to have that, they're scared, like we all would be if we have to have surgery,
right.
But they don't necessarily understand the long-term reason for having it. They just know that it's scary right now, so I don't want to do it.
Right.
Well, then the doctors can't proceed with it, unless you are, one, their guardian, going forward, so you can make that decision for them. And basically what guardianship is, and being their guardian, is it's basically continuing the parental role, right? It's continuing your role as the parent and decision maker to help them make those the best possible decisions for their life and to protect them.
Right. Now, I've heard from people in the past that they say that even earlier than age 18, sometimes in the medical situations, doctors are sort of pushing back and saying, hey, you can't come in the room. Have you heard of anything like that?
Yeah, I haven't. I haven't.
I wish I had got more specifics on that, because I remember a lady telling me that for her son, the doctor would not let them in the room because, you know, he's now essentially a young man at 16 and 17.
Sure.
Let him in the room. So maybe I'll find out a little bit more about that, Ryan, and I'll post a question in this hangout, and we can maybe address it later.
Yeah, I think that'd be great. That'd be great. Yeah, because that shouldn't, you know, again, as long as you're 18, that shouldn't happen that way. So as long as you're under age 18.
Well, tell me how this plays out in the case of, as you know, I'm divorced. Does it make sense to have co-guardians? Is there such a thing as a co-guardian, or how does that work? And Xander's introducing himself. Xander, say hi.
Hey.
Okay. So we all knew that he was going to come introduce himself. So explain to us how that works, Ryan. How does that work?
Yeah, it's interesting because every
sorry about that, Ryan.
I'm okay. It just depends on kind of the area in which you live. Sometimes it can be county by county. Some jurisdictions will let you be a co-guardian, so that both folks can be a guardian. Other ones will only let you be, they have to have one primary guardian, and then they can have a kind of a secondary guardian if that first guardian's unable or something happens to that first guardian, so then it would flip to a secondary guardian. So it really just depends on the jurisdiction you're in and the county that you're in. So you kind of have to ask that question. But certainly it would be it's easier as long as both parents are involved in their child's life, that both of them can have the ability to be the guardian.
How in situations of future, when we're no longer here and we have a future guardian, what are some of the roles and responsibilities of the guardian? You want to talk about that a little bit?
Yeah, I mean, you can have, there's really kind of different levels of guardianship.
Mm-hmm.
So you can have kind of a general guardian, which is going to handle what's called guardianship of the person as well as guardianship of the estate. So what does that mean? Well, guardianship of the person, or you could have a general guardianship and be both of those, or you could just have one or the other, right? And so guardianship of the person is going to be all decisions other than money, right? So healthcare decisions, caregiving situations, living arrangements, anything that has to do with the individual other than their dollars and cents. Guardianship of the estate would handle the assets or income decisions. It would handle if there was somebody trying to get them to, get a credit card and then buy something for them. It would handle those types of things on the financial side, so that they're not taken advantage. They're not being taken advantage of on the financial side. On the financial side, that'll have, again, the guardianship is a court process, and some places it's called conservatorship, right? Or there can be a combination of the two in certain places, and it is going to be kind of a court-watched program, especially if it deals with finances. So when it deals with finances, the court is going to ask for, at least on an annual basis, basically a report of the individual who is either called the ward if it's a guardian, or the conservatee if it's a conservatorship. But the individual that you're taking care of is who that person is, right? Your child. They're going to ask for a detailed reporting of, well, what happened to the money, right? So there is going to be oversight in that respect from the kind of court system to make sure that the guardian or the conservator is doing a proper job.
Is that something that you have to report monthly, quarterly, annually?
It's usually usually on an annual basis. But the court could always ask for it, before a year, right? They can kind of ask for you to put together a report.
Is it something that
responsibility?
Is it something that because I don't know how the process works? Is it something that the court, you have an ongoing date once a year in January, like an IEP sort of, and you're supposed to bring in all the financial information that you're supposed to do? Is that
right?
How it works?
Yep. Usually you'll have kind of an annual appointment. It doesn't necessarily have to be at the exact same time of year, but usually it is an annual appointment to review those items. But they can always adjust it, and if they want you to bring it in earlier, they'll ask you to do that. Interesting.
Does it make sense in some cases to have maybe a guardian of the finances and a guardian of, for example, let's say that my son Xander, his brother is a great person to handle his personal affairs and all the things like that, but may not be, I'm not saying that's the case, but may not be a great financial person. So maybe have someone handle the financial affairs and someone handle the personal affairs. Is there a way to do that?
Yep, you can do that. I mean, the way that I would think about doing that, as you look at the overall plan, is
Mm-hmm.
you could have the guardian of the person,
Uh-huh.
right? And then you could have the trustee, which
Okay.
I know we talked about that last time, kind of those special needs trusts, and the trustee kind of handles all the money
All right.
inside of that special needs trust. So the trustee could kind of be that financial person. And then there's, a little bit less rigid oversight
Mm-hmm.
of those financials when you do it that way, because the trustee is a private arrangement.
Okay. I guess maybe I'm getting a little confused. Could you explain to me the difference between a guardian and a trustee?
Yep.
In layman's terms, because you know me, I'm not that bright.
Oh, I don't believe that's true, everybody. Yes, the guardian is going to be court appointed,
Okay.
right? So the guardian has to go through the court system.
Mm-hmm.
And so there's going to be a lot more oversight by the court system on that guardian. And it's going to be more structured and more rigid in terms of that oversight.
Mm-hmm.
The trustee, well, as a parent, you've set that up privately.
Mm-hmm.
So it's a private arrangement between what you wanted and who you named as the trustee.
Mm-hmm.
So, there's not as rigid of oversight from the court system, right? The only thing that's going to be oversight on a trust and a trustee arrangement is, the Social Security office may call on the trustee to report on what you've paid for out of the trust. But that's more on the government benefit side and qualification side, because they want to see, is this trust being used appropriately in reference to the government benefits. The guardian side, the court system wants to know, is the money being used appropriately for the child, and is this guardian stealing stuff? Right? And that's more of what they're concerned with on the court side, is because when it's a guardianship process, the court is really going to be primarily, they're kind of the responsible party, right? So the guardian kind of goes to them, because the court system can always kick your guardian out and pick a different one. They have that ability to do so if that guardian's not living up to what they're supposed to be doing. So there's a lot more oversight there from the court system than there would be in the trustee side, because that's a private arrangement.
Well, it sounds like, and correct me if I'm wrong with my understanding, it sounds like the purpose of a guardianship is to continue the ability for you to manage your child's affairs after turn 18, right? So that you can go to IEP, so you can make medical decisions, so you could be involved. If you, and because being just a trustee within a special needs trust, that doesn't give you the legal authority to make decisions on behalf of your child at the age 18. Is that correct?
You got it. You're exactly right.
But you can still make the monetary financial decisions as the trustee on the trust side.
Yes.
Right? But by becoming the guardian, also, you're saying that because you have to, if the child's 18, he's not able to make his own decisions, you need to be the guardian. That involves the court.
Yes, you got it. You're exactly right.
That involves the court on the financial side. That involves the court on everything, right? Just primarily the financial side. Okay.
Yeah, mostly the financial side, because they want to make sure that the guardian's not stealing the money.
Right. So in cases of having a child that can make his own financial decisions, and theoretically has also his own medical decisions, but you still want to set up a special needs trust for him. You don't necessarily need to do the guardianship, because he can make those kind of basic decisions, but the special needs trust could be set up to provide financial resources available for him.
Exactly. You're exactly right. And so it would still be so for example, we have several families that have, and again, whether we all like these terms or not, it's the terms that we all know and use. But so if we have an individual that is, high functioning,
Mm-hmm.
right, and we're not really sure, do we need to do guardianship? Do we not? I mean, it's kind of that individual you just described, right? Well, they can kind of understand kind of a little bit about money, and they kind of understand their medical decisions, and we don't want to take those decisions away from them and have to make them for them. You still want the trustee side because that helps them really manage kind of the long-term dollars, but also helps to qualify for the other government benefits, right?
Mm-hmm.
So that's why you'd still want the trustee side. If your child's, if you're not sure if guardianship's really necessary, you may want to do a couple different alternatives, right?
Mm-hmm.
And so a couple of those alternatives on the financial side would be a kind of a durable power of attorney,
Right.
which allows you to help them make financial decisions or to step in
Mm-hmm.
if at some point they are deemed unable to make that decision. Then you can step in and continue that and make sure that things are appropriately put together there. And then you could also be their healthcare power of attorney as well, which again, you can't force somebody to do something medically with a healthcare power of attorney, but if they're unable to communicate with the physician or unable to make a decision, just because of they're not able to speak, they're not able to, maybe they're they had some kind of injury where they're not able to communicate, then the healthcare power of attorney can step in and start to make those decisions in those kind of emergent situations. But just going to a doctor's appointment with a healthcare power of attorney doesn't mean that they're going to let you into the appointment.
Interesting.
Does that make sense?
I'm correlating this to my father. He's got dementia, and my brother has a durable power of attorney to be able to make decisions for him. I'm sort of equating that to that in that capacity. So there's really some decisions need to be made, and I think this is where your firm sort of helps out with. But the decisions need to be made. Do you want to get into do you want or need to get into the court system situation where now you've got to report to the court annually? Not that we're afraid of that, but it's just a burden, an additional burden that's initially on you, and then potentially on someone else later on when you're no longer here, a brother, a sister, a sibling, a cousin, or whoever. As this additional burden as a guardian. And in some cases, you're going to have no choice. If your child can't communicate, you're going to have to get that done. Yes. But then there's alternatives like you're talking about, the durable power of attorney for medical and for financial. Would that serve your needs as much? And thinking that through, I don't know the answers to that yet. I mean, my kid's only 10, so I've got 7 years to see where he's at that moment. But if I'm looking at it now, he's not able to talk very well. That doesn't change in the next 7 years, and then I might need to do those things. So,
and we'll make sure we walk through that with you, Keith.
Absolutely, absolutely. But it's sort of insightful because I didn't know there was all the other alternatives that were available for parents, and I hadn't drawn the parallel between taking care of a child with special needs and taking care of my father with dementia. Although very, very, very similar.
They are, yeah, yep. You're absolutely, and a lot of that, a lot of, and when you think of, a lot of attorneys that will do special needs work will also be what are called elder law attorneys, because it's different, but it's similar because we're still talking about individuals that need help on a daily basis.
Right.
Some of the techniques and some of the specifics are obviously going to be different. But the general idea is, okay, this individual needs some help. How are we going to do that?
Right.
And so you see a lot of elder law attorneys may also have some expertise in special needs as well.
Interesting. Now, let me make sure I asked you all the questions I did ask you earlier about how long it takes, and you said about six to 8 months. You should start in advance of their 18th birthday.
Yeah, I mean, and it can be a lot faster than that, but it just, again, what I always suggest is, get the paperwork, make sure you understand it, start filling it out, ask some questions, if we don't understand it, so that you can get it, so you can go back and just make sure it's completed properly.
Right, right, okay. And you would help, your company would help people with that in the jurisdictions.
Yep.
Not as attorney, but as help them understand what needs to be filled out, what needs to be done, how to answer some of the questions, that kind of stuff.
Yes. Yep. That's part of what we do for families.
And then having that dialogue with families about other alternatives and see which might be the best fit. And you might not know until your child gets closer to 18 to see where his mental capacity is and his ability to make decisions for himself is at that moment. Like
Right.
I wouldn't decide today I'm going to make a guardian because he's still got another 7 years of whatever, but it's just good to know that those are the other options that are available out there. Because I am not alone, that I'm a little reluctant about getting in a court system situation where I'm obligated to continually respond to them. And I'm also hesitant to force that upon future guardians if it's not something that's absolutely required.
Right, which is why it's great to have the setup of, hey, have the special needs trust and the trust with the financial pieces and the trustee, and then just have guardianship of the person through the court system, and then there's less oversight because they're not as concerned, because the guardian's not really handling all the money. They might just be handling a checking account. They're not handling all these other pieces.
I can't believe I missed that. I didn't catch that. You could still have it split that way. Have the trustee and the special needs trust handle all the finances, and then the guardian handle all the medical decisions and all that kind of stuff.
Right, and so and in reality, for a lot of families, be the same person.
Right.
But the court system doesn't know that. Right. So they wouldn't be involved because, again, the trust is a private arrangement.
Excellent, excellent. Well, Ryan, we're at our 30-minute timeline like we always like to stick to. I know we've covered a lot of great information. Is there something that you want to make sure that we communicate to people out there before we wrap up?
Yeah, just one thing, because I know it was something that you mentioned, Keith, which I thought was great. We were talking about the fact that your son's only 10, so this decision doesn't have to be made yet, and that's absolutely true. The decision, though, that has to be made, however, if your child's a minor, right, under age of 18, is, God forbid, something happens to you and your spouse, well, you still need to pick a guardian for now because they're only 10, right? He's only 10. And so you still need in your will to choose somebody who's going to care for them going forward. So that's the piece of guardianship that obviously we can't wait on, because if we get hit by a bus, we don't want the court system deciding who's going to take care of them.
So this is a good point. So you're saying that even though my child's only 10, that in my will I need to designate who the guardian would be in the case of something were to happen to me and his mother.
And right, exactly. Yep. Especially because, and I know you're always open with this, so I'll use you, but especially in a divorce situation, right? I mean, if as long as both people have custody, right, have some level of custody, then if one parent dies, the other one's automatically the other parent, right? So it's automatically going to be, that's who it's going to be, unless again, as long as both people have legal custody in that proceeding. So so that's going to happen automatically. But if something happened to both you and your wife, then, we need to know, we want to guide the court system on who that guardian would be. And then that guardian, right, if our child's a minor, so we're 10 years old, if that's the case, then what you're doing is you're going to leave that next guardianship decision to that one, to that guardian you name, right? Because they're going to make the decision at age 18 if they need to continue to be the guardian, and then they're going to go through the guardianship proceeding just like you would have if you were here.
So, this brings up, and I know we're going on, but I think this is important, and it might be important for other people who are watching too, who are the product of a divorce situation. So in my case, if I were to pass first, then that my children would automatically go to my ex-wife. But if she were to die first, and she's currently remarried, has a husband, and they have two children, which are the half brothers and half sister of my kids.
Mm-hmm.
Now the kids come to me, and then I were to die before, what happens in those cases? I guess in that case I would be the one making the decision for my kids, and I would want to consider, whether or not I'd want my kids to be raised by my ex-wife's husband, current husband.
Right.
Is that confusing?
Yes. Well, it's not confusing. I think I got it. But there's more. When families are blended together, right? There's much more to think through. Because there's
I'm sure that if she was doing this guardianship discussion, she would say that she wants her current husband to be the guardian. I'm sure that's what she would say. I, on the other hand, would not want her current husband to be the guardian. I would prefer it to be someone in my family. So I guess it's all about timing of who goes first. Not that we're both young and relatively healthy. I'm sure that that's not an issue, but things happen, as you know, Ryan, and circumstances change on a dime. So fortunately for me, my ex-wife and I communicate very, very well, and we co-parent very, very well, and we could probably sit down and sort of talk about this. But that's not always the case with all divorced families. Sometimes it's a little less pleasant, but it's something we need to think about, and we need to put our child with special needs first, right? In that discussion, put aside any issues that you have with your ex and talk about what's best for your child, because when you're both gone, you want to make sure your child is taken care of. He's not left in the world in some legal mess, right?
Yeah, absolutely. Between different family members fighting and those types of pieces. So, and a lot of times we do, for us working with different families, a lot of times we act as the I don't know as the third party. It's not really a referee because it's not, it's,
right.
I mean, you can
Sometimes
say
it might be referee.
yeah, but it doesn't usually end up like that. But it is more of a I know I had one family, and it sounds like you and your wife, they got along really well,
right.
But they're just not married anymore. So it was very interesting because I basically had almost 3 different plans that I had to build together.
Right.
But not tell the other one about one of the plans, right? Because one of them was, hey, this is Keith's vision for the rest of his life and his kid's life, and then you have your ex-wife's vision for her life, as it is now, which neither one of you, it's not either one of each other's business what that looks like.
Right.
And then the middle plan is specifically about your one child, right? That we both need to understand how that's going to work. And how that functions. So a lot of times it's 3 different plans. I remember I was with one family, and literally we just worked all day together. One came in for an hour and a half by themselves, and then they came in for an hour and a half together, and then the one that came in the morning left, and the one that came in they don't have stayed for an extra hour and a half.
Wow.
To make sure that we kind of blended everything together appropriately.
And this is a perfect example of why it's so important to work with someone who specializes in this, because if you just work with a financial planner who doesn't really understand all the nuances and all the various scenarios, you can really get yourself in a bind. And unfortunately, when you get yourself in a bind, it doesn't come to fruition until you're no longer here, and then your child or future caregivers are dealing with the headache. So this has been very, very informative, Brian, as they all have been, and you're always just a wealth of knowledge. I know coming up, we have beneficiary, coming up in a couple weeks, we have beneficiary designations. Can you give us a quick snapshot of what that looks like and what we'll be talking about in a couple weeks?
Absolutely, man. Again, we've talked a lot about in the last 2 weeks about kind of legal pieces that are going to be important, right? Kind of your directives, your will is going to tell people what you want to have happen to your stuff, to your children. And so beneficiary designations is one of those small things that it's amazing. I know that people are probably thinking, why are we having a 20 to 30 minutes on beneficiary designations? Are you kidding me? How much can we talk about that? But the reason that we want to talk about them is because they supersede what your will says. So if we don't have those right, and we don't make the proper adjustments there, then everything you did in your will and all those legal documents could be for nothing. And so we want to make sure we understand how they work, and understand what we need to do with them. So again, they're linked together with all the other pieces.
Right, right. Well, I'm looking forward to it, because I was too wondering, well, what are we going to talk about for a half hour for just, all right, switch it to the trust. But I see why we need to have a discussion of all the things that parents need to do as they're designating their beneficiaries. So I'm looking forward to that in a couple weeks too, Brian. So I want to sort of wrap up the conversation today. As usual, awesome job, Brian. You're just a wealth of information, and your company just does great work, and I appreciate you doing these things. I think it's incredible. So,
my pleasure.
So with that, we will go ahead and finish up. Thank you, everybody. I appreciate you joining. If you have any questions, please continue just to add them to the comments here, and we will get back to them when we have a chance. Thank you, everybody.
Thank you.